thorough and sifting cross-examination of that because she hadn't looked at the report. She didn't even know where one of them was. In the end, we talked about the inconsistent statement. She had access to somebody that could have completely rebutted that. The pastor, who the letter was supposed to, and she didn't. He's right there. His church is right there. Didn't contact him.
How would she have rebutted that with the pastor? Well, it was not properly admissible.
This letter was a letter that did come in that said that Mr. White was in jail and wrote this letter to his pastor that so-and-so confessed this, that my client, Ms. Chapman, wrote that confessed to this arson. Well, if you called Mr. Mills, the pastor, he said he has no earthly idea who Joe White is.
Why does that mean that it's not? Why
well, if Joe White's writing a letter to his pastor and the pastor's never seen a letter or never heard of Joe White, there's going to be, that gives you some pretty good fodder for cross-examination about that this letter is just trumped up so that Mr. White could get himself a little bit better deal in another case, which he was facing. He was in jail. He was a jailhouse snitch. And had she even been to the scene, she would have been able to tell that where the witness, who supposedly saw Mr. Chapman, claims he was standing and claims where Mr. Chapman was standing, you could not see the house. It was impossible to see it from there. Had she even interviewed the witnesses. Instead, she spent a lot of time chasing down this green van that somebody saw that was basically irrelevant. And the point there is, it doesn't mean that a defense lawyer shouldn't chase down some of these maybe less than solid leads, but you've got to have enough time. You've got to plan, or you've got to, grovel to the court. Or worst case scenario, you say, Your Honor, I'm not prepared. Do what you have to do to me, but we can't go forward with this trial. Thank you.
You tell me for the state.
May it please the Court, my name is Jay Fisher from the Attorney General's Office, and I represent the state in this matter. I certainly will concede that the motion for new trial, the events at that, created an interesting scenario for this Court to consider. There's two issues here that I think are important to set out right from the beginning of my argument. A lot has been said about what the District Attorney's Office would do or would not do at the motion for new trial. It's a matter of public record that there were different district attorneys at trial and at the motion for new trial. So to sit there and say what one district attorney would do and the other district attorney would do, I think is speculative at best. The other issue, too, that is kind of hovered.
They're coming out of the same office, though. I mean, it's kind of like you say, you got a DA that's over it all. That's hard for me to.
Well, I agree.
That's a hard sell to me.
I understand, Your Honor, but at the same time, there's a consideration of having two individuals and how they would interpret this and exercise discretion in the matter. The other issue that's hovering over this is the whole issue of hindsight. Strickland expressly forbids hindsight to be an evaluative tool when assessing ineffective assistance, and I think that there's a lot of armchair quarterbacking here regarding what counsel did or did not do in hindsight. Taking up the issues here in the order that were presented in the appellant's argument regarding the polygraph, Strickland not only requires a showing of error and prejudice, but there's a case out of the Court of Appeals that says that in the realm of whether a polygraph is or is not administered, you have to show that the evidence is admissible and that the state would have entered into a stipulation regarding the polygraph. There's deficiencies in both of these areas in the facts of this case. Appellant may say that he has a polygraph and in fact can present it. The problem being is that the state never voir dired the expert. The merits of that polygraph were never independently evaluated by the state, so we don't know about its admissibility. Second, there's no evidence in the record saying that the state would have stipulated to a polygraph had one come up before trial. So as such, we have these key missing facts from the record in this matter, and you can't find ineffectiveness if there's these glaring holes in the appellant's argument.
Well, he seems to be arguing, though, that the state would have taken a different tact as far as charges or sentence for a plea had the polygraph come out early.
Well, again, that goes to what these individual district attorneys would have done at the time, depending on who's sitting in the office. But even so, you can't sit there and say for certain that if a polygraph came back that the district attorney would have, in fact, done something different because of basically the value of that polygraph under Georgia law. I mean, a polygraph, as has already been mentioned, has to be stipulated by the parties to come in, but a polygraph in and of itself is not hard scientific evidence of innocence. Under the Georgia law and the way jury charges are patterned on it, polygraph is basically just opinion evidence only, and it's charged that way to the jurors. So the jurors basically can put whatever weight and value they want on a polygraph when assessing all the other evidence. So it's hard to sit there and say that the DA would have done X, Y, and Z with a polygraph when the polygraph itself is just basically one piece of evidence in this whole picture that's been shaped by the district attorney's office as well as the appellant. Regarding the juror issue, I think this issue is quickly disposed of because voir dire was not transcribed in this matter. There's no record before the court showing the individual questions that were asked and whether any kind of bias or prejudices were in fact examined in the jurors.
What is in the record with regard to any discussions with the court reporter?
I don't even have any records of the court reporter regarding the transcript existing or where the tapes are, so I can't make a competent discussion on that. I don't even know if there was any evidence put in informally by the parties regarding the existence of the tapes to make a transcript. So based upon that, everything that would be, in fact, argued by the appellant regarding the juror issue, again, is speculation.
Mr. Fisher, you said voir dire simply was not taken down, or they don't have a transcription of it.
Well, I don't want to say it wasn't taken down. It could have been taken down in tapes. There might be some form of a record of it having been made, but in terms of it being a formal transcript that's in the record before this court, it doesn't exist. Now, even assuming that a lot of jurors were related to law enforcement, that in and of itself is not a reason for finding ineffective assistance of counsel. I think as Justice Namias was mentioning, you have to find that these jurors were somehow prejudiced or biased in their ability to assess the case based upon their relationships. There's also no record of just how closely related these jurors would have been to these members of law enforcement, so it's hard to say if we're talking twin brothers or twin sisters or fourth cousins twice removed. There's just, again, it's totally speculative. Regarding the issue of the fire experts and counsel's ineffectiveness at basically looking at the evidence on that issue, the trial court concluded that the defendant's attorney was in fact effective based upon the cross-examination and the records of same and her ability to show deficiencies in the state's case with these particular experts. There were two state experts who testified about the fire. An examination of the record shows that counsel was able to get from both of these experts that they couldn't find any evidence of accelerants being used. Counsel also highlighted that these two experts, when they actually did their on-scene investigation, did not obtain samples from other parts of the burned house to test for accelerants. Now, in closing, she argued not only the fact that the accelerants weren't present at the crime scene, but she also argued that the state's investigation in this case is incomplete. Basically, they didn't go and look at the entire scene or take samples from the entire scene, didn't test the scene for other places where the fire might have started. She was also effective in highlighting during her cross where the exact origin of the fire came. Did it come from inside the door? Did it come from outside the front door? She's able to highlight discrepancies, and based upon this, the trial court concluded that trial counsel was effective, at least as far as the state experts. She even went one step further, though. She brought in her own expert, not necessarily on fire scenes and investigations, but this was an expert on criminal investigations generally. He did have experience in arson cases, and he was able to testify that at least the crime scene, as he reviewed it, was in fact, the arson itself was based on revenge. He also testified about the lack of accelerants as well. As I mentioned before, this was all argued in closing, and so the defense attorney was able to put together a competent case on that issue. And the final issue regarding the pastor's letter, I know that there's kind of a very strange fact scenario with the motion for new trial, because this was the basis whereby the DA and the defense counsel or appellant's counsel said that a new trial was warranted. There was saying that it was hearsay. It wasn't hearsay. I mean, it was a prior consistent statement. That was the purpose for admitting, I should say, when I say admitting it, the letter itself was not admitted into evidence. Only portions of it were read to the jurors by one of the state's investigators, the pertinent portions. A lot of it was, in fact, kept out and kept from the jury's consideration. It also should be pointed out that trial counsel did make 3 attempts to exclude the letter. She objected on it on 3 bases. One, that it was irrelevant based upon the other portions that had no bearing upon the trial. That also that there was a problem with authentication, and that also there was a problem where it was basically bolstering the witness, Joseph White, who'd already testified at trial. I believe that appellant's now saying, well, maybe the 4th time was the charm. Maybe she should have objected on hearsay grounds. But an examination of the letter of itself shows that it was clearly a prior consistent statement to show that Joseph White was in fact not lying or was not trying to somehow create a situation where he could get a better deal with the state, because he was communicating with someone who was essentially a disinterested party and testified the same as to what he presented at trial. So
What about Mr. Little saying that the pastor says there was no such letter?
Well, if basically I think that's a red herring, Judge. And what I mean by that is that whether it went to somebody that he claims was his pastor or just a complete stranger, it's whether Mr. White, in fact, communicated that to whatever third party. It's not a question of whether or not this person received it or even knew of Joseph White. It's whether, in fact, Joseph White made the statement, which in fact was consistent with the statement that he gave to law enforcement prior to trial, as well as his testimony at trial. So as such, I think really the recipient is an irrelevant issue.
I guess the question of authentication, who authenticated Mr. White?
The issue of authentication was, in fact, presented through the state's investigator, who testified about receiving it, and also I believe, and I apologize that I don't have this fact on the readily available, but I believe he also talked to Mr. White and was able to confirm, in fact, that the letter was his, but it wasn't done formally at trial with Mr. White. So if the bench has any other questions, and if not, then the state respectfully requests that you affirm the convictions from the lower court. Thank you.
Thank you both. This court stands in recess.